M.K. Nambiar Chair on Constitutional and Administrative Law and School of Legal Studies, First National Moot Court Competition 2023. The final round of the competition is happening here. I request everyone to be seated inside the auditorium. The final round will begin soon. Here the teams who are contesting against each other are BMKN 10 and BMKN 15.
Good morning, everybody. So, we are on the final stage of the rounds of competition. Today, we have Justice Mohammed Mustaq from High Court of Kerala, Honorable Judge. Let us welcome him for the final rounds of Moot Court competition under the Barrister M.K. Nambiar Chair. We have Justice Mohammed Niyaz, who is also the Judge of the High Court of Kerala. Let us welcome him on behalf of Barrister M.K. Nambiar Chair on Constitution and Administrative Law, Kannur University. We have also Advocate P.V. Dinesh from Supreme Court of India. Let us welcome him on behalf of Kannur University. I welcome both the teams who are contesting on the final rounds. Team number 15 and team number 10. I welcome the court managers, welcome all the participants, teachers, students, honorable registrar, and everybody assembled here. So, let us begin the final rounds of Moot Court competition 2003. Thank you.
Good morning to all. Welcome to the final round of the first National Moot Court competition organized under the auspices of Barrister M.K. Nambiar Chair on Constitutional and Administrative Law, School of Legal Studies, Kannur University. We have our participants, BM KNF 10 for petitioner, BM KNF 15 for respondent, counsel for petitioner.
Permission to reserve the bench to the lordships. Much obliged. May it please this honorable court that I, along with my co-counsel, represents petitioner in case of Aga Khan versus Union of Mewar and others. I seek permission to move to the statement of facts. Much obliged. Republic of Mewar and its constitutional provisions. Republic of Mewar is sovereign, socialist, secular, democratic republic with a written constitution and parliamentary system of government. Fundamental rights are guaranteed in Part 3 of its constitution, which assures efforts to its people. From Article 14 to 18, the Equality Code as fundamental right is enshrined in the Constitution of Mewar. Article 14 provides for the equality before the law or the equal protection of the law within the territory of Mewar. Article 15.4 and 15.5 provide reservations in educational institutions for the socially and educationally backward classes and scheduled castes and the scheduled tribes. Article 16.4 allows for the reservation in appointment or post for any backward class of citizens who, in the opinion of the state, are not adequately represented in the state services. The makers of the constitution use quota system in the form of reservation policies by reserving seats for underrepresented categories of citizens in public employment, educational institutions, and legislative bodies, also known as affirmative action. The impugned constitutional amendment in Constitutional 103rd Amendment Act 2019, new pool of reservations namely economically weaker sections was introduced by the Parliament of Mewar by incorporating Article 15.6 and 16.6 in the Constitution. Article 15.6a empowers the state to make sure provisions for the advancement of EWSs of citizens other than the SCs, the STs, and the SCBCs. Article 15.6b B provides that such special provisions shall relate to their admission to educational institutions, including private educational institutions, whether aided or unaided by the state, other than the minority educational institutions referred to in clause 1 of Article 30, which in the case of reservation would be in addition to the existing reservation and subject to a maximum of 10% reservation of the total seats in each category. Explanation under Article 15 clause 6 provides that for the purpose of Article 15 and 16, EWSs shall be such as may be notified by the state from time to time on the basis of family income and other indicators of economic disadvantage. Article 16 clause 6 empowers the state to make provisions for the reservations of appointment of post in favor of any EWSs of citizens other than the classes mentioned in clause 4 of Article 16. In addition of the existing reservation and subject to a maximum of 10% of the posts in each category. The constitutional amendment was challenged. A bunch of petitions challenged the 103rd Amendment, which came into effect on Jan 14, 2019, and a 5-judges constitutional bench of the Supreme Court of Mewar heard the matter. Constitutional validity was upheld. The 5-judge bench upheld the constitutional validity of the 103rd Amendment by 3:2 ratio. The dissenting judgment held that the 103 Amendment is violative of equality principle, that is, exclusion of the SCs, the STs, and the non-creamy layer of the OBCs, and hence it's against the basic structure of the Constitution. Review petitions and its grounds. One of the petitioner, Aka Khan, filed a review petition before the same bench on the following grounds. Ground number 1. The petitioners challenged the term economically appearing in the 103rd Amendment, which cannot be isolated from the weaker section. The 103rd Amendment excludes the SCs, the STs, and OBCs from the purview of weaker section, which is violative of Article 46 of the Constitution. The 103rd Amendment for 10% additional reservations to EWSs is breaching 50% cap for reservations, and it cannot be solely on the basis of economic criteria, which was settled by the decision in this court in Indira Sohani versus Union of India. Different studies and reports relied upon to determine EWSs were insufficient. Maximum of 10% reservation to EWSs is disproportionate to a small number of people belonging to EWSs. The EWSs reservation allotted to unaided and private educational institutions is against the Article 19(1)(g) of the Constitution. EWSs are determined by income less than 8 lakh by many states in Mewar. This is contradictory to the exemption from the income tax on the income less than or equal to 2.5 lakhs according to the Mewar Income Tax Act. The Council seek permission to move to the issues. The bench may refer to page number 11 of the memorial. Article Your Lordship, I will try my best to emphasize on the term review itself. It is a humble expression. It means to look again. The petitioners are humbly requesting to the Supreme Court to look again into the matter on the grounds that are mentioned.
Those grounds we have already argued in our judgment and we give a verdict on merit. Then what for us to decide on review?
Your Lordship, Article 46, Article 40 are two basic criteria for the petition to be held. 46 allows for this aid to be provided to the weaker section, but along with SC, ST, and
How
OBC.
this review is if we can go. What is scope? Tell us what is scope. How the circumstances.
This is not normal circumstances. The Council would like to emphasize this is the topic of reservation, much debated and a fragile topic in the country.
Therefore, rehearing is permissible.
This is not rehearing, which is in the matter of appeal. This is a review petition.
On what grounds? When is the review maintainable?
The review is maintainable when there is an error in the face of records or
What is the error?
the error in the face of record is the precedent, Your Lordship. The precedent of Indira Sohani judgment was not taken properly into the consideration.
Exactly. That is a ground according to
Yes.
Last charge by the court have not been considered properly.
Larger bench. May I proceed with the issues? Much obliged. There are a total of 4 issues involved. Issue number 1, whether is there an error in the face of records. Issue number 2 is exclusion of the SCs, the STs and the SCPCs from the purview of FICA section and making it exclusively for the EWSs is violative of Equality Code, which is the basic feature of the Constitution. Issue number 3, whether additional 10% reservation reaching the 50% cap is violative of the basic structure of the Constitution. Issue number 4, whether giving reservation solely on the basis of economic criteria is violative of the basic structure of the Constitution. The Council shall be dealing with issue number 1 and 2 and my co-counsel shall be dealing with issue number 3 and 4. The Council shall be speaking for a total of 20 minutes and the co-counsel for the total of 20 minutes, reserving 5 minutes for the rebuttal respectively. The Council seek permission to move to the summary of argument issue number 1. Much obliged. It is humbly submitted before the court that in Indira Sohani and others versus Union of India, this court with a 9 judges bench in 6:3 ratio decided a rule that 50% is the ceiling limit in reservation, and in the present case, 5 judge bench in 3:2 ratio upheld the 103rd amendment, which gives for the maximum of additional 10% reservations apart from the existing reservations, which apparently breaches the 50% ceiling cap set by the larger bench of this court. This is clear in the parental and in the face of record by this court, which is contravening its own decision given by a larger bench. The Council seek permission to move to the advanced argument of issue number 1. Much obliged. The Lordships may refer to page number 14 of the memorial. It is humbly submitted before this court that the doctrine of binding precedent is not being followed by the Honourable Court in the present case.
Was there any decision on this economic criteria?
Previously to this, it was said that economic criteria solely cannot be a reason enough.
What was the issue there? What was the background of that philosophy? Was it related to social background?
Indeed, it was.
And larger than considered an issue related to economic.
It did, and judgment clearly stated the economic criteria solely cannot be a basis.
Can put in observation. That was not the issue there.
It was not the issue, but the observation is precedential in nature. It was given in a landmark
It
case.
is only a vital. It is not an issue.
The entire case right now is depending upon that important precedent, which was directly stated that the sole reason, and the philosophy of reservation itself talks about the heterogeneous status of the classes that should be involved.
Two kinds of reservation. One more people know. How we classify this economic reservation?
Your Lordship, this is a horizontal reservation.
What was considered in those studies?
Your Lordship, the grave point here to be noticed is it is an economic reservation which lacks many criteria. It does not really give data of what portion of population really requires it. It gives a guideline, but there is a complete vagueness in how it will function. The state have not clarified upon that till today. Much obliged, Your Lordship. May I continue with the issue? Much obliged. Article 141 clearly states, law declared by Supreme Court to be binding on all courts. The law declared by the Supreme Court should be binding on all courts within the territory of India. In this article, we can see the binding precedent principle given by the Constitution of Mewar, but Supreme Court is also binded by its own precedents by the larger bench. In the present case of the 5 judges bench in the ratio 3:2, upheld the additional 10% reservations to EWSs apart from the existing reservations. This clearly breaches the 50% ceiling cap on the reservations in the Chandra Savari case. The judgment in Chandra Savari case was given by the 9 judges bench in 6:3 ratio, which is larger in comparison with the smaller 5 judges bench. The relevant observation in Central Court of Dawoodi Bora community was made by Justice R.C. Lahoti, and I read. In para 12 said case, he said, and I quote, the law laid down by this court is that in a decision delivered by a bench of larger strength is binding on any subsequent bench of lesser or forceful strength. A bench of lesser
What
quorum.
constitutes a binding precedent? What constitutes a judgment document to be binding?
What was held important in the
How do you say a judgment is binding? There are many observations. How do you say what basis? Say a judgment document.
Your Lordship, this is the apex court. The apex court's judgment.
Yes. But how do you say a judgment is binding? What constitutes a binding? What factors?
The council seeks pardon for lacking the knowledge upon the subject. May I proceed? Much obliged. The bench of lesser quorum cannot doubt the correctness of the view of the law taken by a bench of the larger quorum. In case of doubt, all that the bench of lesser quorum can do is to invite the attention of Chief Justice and request for the matter being placed for hearing before a bench of larger quorum than the bench whose decision has come up for the consideration. In present case, we can clearly see that the 5 judges bench already disregard the law of 50% cap on reservation laid down by the Honorable Court in the decision of Chandra Sawari. The Council seek permission to read the summary of the issue number 2. Much obliged. The impugned amendment is violative of equality code by excluding the SCs, the STs and the OBCs from the purview of weaker sections, hence violating the basic structure of the Constitution. It's humbly submitted before the court that the impugned amendment is violative of equality code by excluding the SCs, the STs and the OBCs from the purview of weaker section. The special provisions for the advancement for backward classes in education and employment are not against the equality principle, which are well against Article 15.4 and 15.5 and Article 16.4, but excluding them explicitly from additional reservation dedicated for AWSs really violates the equality code. In Janhit Abhiyan versus Union of India, Honorable Mr. Justice S.R. Bhatt stated, and I quote, "This court has for the first time in the 7 decades of the Republic sanctioned an exclusionary and discriminatory principle. Our Constitution does not speak the language of exclusion. In any considered opinion, the amendment is in the language of exclusion and violates the principle of justice and thereby the basic structure." The Council seek permission to move to the advancement of issue number 2. Much obliged. The bench may refer to page number 15 of the memorial. It is humbly submitted before this honorable court that this is worthwhile to take a look at the Constituent Assembly's thoughts and opinions about reservation. In the Constituent Assembly regarding reservation, Professor K.T. Shah has proposed an amendment to clause 2 of the draft of Article 9, now clause 3 of the Article 15 for adding words of scheduled caste of backward tribes for their advantage, safeguard and betterment. The object, he stated, was, in regard to the scheduled castes and backward tribes, it is an open secret that they have been neglected in the past, and their rights and claims to enjoy and have the capacity to enjoy as equal citizens happen to be denied to them because of their backwardness. I seek therefore by this motion to include them also within the scope of this subclause 2, so that any special discrimination in favor of them may not be regarded as violation of the basic principles of equality for all classes of citizens in the country. For the particular statement, your lordship may refer to flag number 11, page 21 of the compendium submitted. By here we can interpret that for reservation to be given, some sort of historical discrimination should be there, and there have been no conscious discrimination for EWSs. It would be worthwhile for the Honorable Court to take a look at the philosophy of reservation. Reservation is considered as affirmative action by the state, which means a positive action to uplift the oppressed class to the mainstream society. The Constitution put forth 2 major elements to recognize a class as entitled for the reservation through Article 16.4 and Article 16.4 read, and I quote, "Nothing in this article shall prevent the state from making any provision for the reservation of appointments or posts in favor of any backward class of citizen, which in the opinion of the state is not adequately represented in the service under the state." By here, your lordship, we also like the data upon what is the population that is underrepresented that belongs to EWS. The 2 major elements to recognize a class as entitled for reservation are first, backwardness, and second, inadequate representation. The classes which are backward means that these classes have faced historical repression and are disadvantaged.
Is there any prohibition under the Constitution against reservation for economic impact? Is there any prohibition under the Constitution?
In Article 15 or 16, from making the economic criteria also. Is there any prohibition?
No article in 15 or 16 reads for economic. It has been favoring socially and educationally backward
Does it
classes.
mean that you cannot take it in the form of reservation?
The
On the basis that it will, what criteria then to be used?
As Justice Bhatt debated in this very court, in the very case of Janhit Abhiyan, he says that the section of the society that my learned counsel is going to talk about can very well be dealt in the purview of 46, but to invite them on the exclusion basis directly to the 14, 15 and 16 is not permissible. And as far as it is for equal opportunity, 16(1) already grants that.
The opportunity is not mentioned in the existing. Then how do you analyze and when economic reservation is being, what constitutional parameters would be required by you to say that it makes the constitution law?
As far as reservation is discussed, it explicitly talks about and keeps stating the social and educational backwardness.
Only affirmative action to be given by the state. That is only stated in the
The bar is not there indeed. But this is reservation. We have to go back to... Indeed he did.
It was upheld like economic reservation.
He did upheld economic reservation. Reading the grounds, he did upheld it on the present scenario may be admissible that society may need an economic reservation, but on the grounds of exclusion of SC, ST and OBC, it is not admissible. It directly violates 14 and 15. And
according to this, some group has to be formed within a given group of reservation and then form a reservation for the social backward based on economic criteria.
the contention of the council here would be that the reservation is a very big step to be taken. It's a very fragile step to be touched. First, the government should have tried to use the methodology of scheming and policy making. If there was recognition of such new class. Your Lordship,
based on the class, this subclass.
Your Lordship, the contention of the council is there is indeed a procedure to be followed. If such deprived class has been recognized, the process should start with recognizing, with collecting sufficient data and reading upon it, and then starting with policies. For example, the economic reservation is trying to aid that particular class in economic factors and opportunity factors. The same criteria is dealt with below poverty line cards that governments supply. That card also aid those who are economically backward. And
the economic criteria being applied in the vertical group of SC and SC.
The word economically in itself. Indeed, so Your Lordship, the creamy layer is excluded from the reservation.
That is in SCBC. What scheduled caste scheduled tribes. They are getting reservation irrespective of the economic level.
They are the lowest of the lower classes, Your Lordship. They are the most deprived classes of the country. The history repeats.
The economic criteria being followed.
They required, Your Lordship, when their reservation was given to them, they were living in the times, even before the time the reservation was given.
Yes.
That is the basic, that we had to uplift them in all the possible sense back then. That was an action taken in favor. It was said in the debate itself, in the constituent debate, that if providing some sort of upliftment to them boost the development of the country, it should be given. The council shall request the bench to refer to page number 18. It is humbly submitted before this honourable court that equality is the integral part of the constitution, and by excluding the SCs, the STs and the OBCs, integral part of the constitution has been disrespected. The 103rd amendment has explicitly incorporated the word other than the class. This is the basic contention right now. Other than the class. In Article 15(6)(b) and Article 16(6), these incorporated articles clearly exclude the classes which are mentioned in clause 4, 5 and 4 respectively. This is clear disrespect towards the equality.
Yeah, you can have 3 more minutes.
Much obliged, Your Lordship. It is humbly submitted before this honourable court that the state has affected the right to equality of SCs, the STs, the OBCs, the SEBCs by reducing their seats. In Saurabh Yadav and others versus State of Uttar Pradesh and others, Your Lordships may refer to flag number 21, page 29 of the compendium submitted. Justice Uday Umesh Lalit says in para 31 of the said case, and I quote, subject to any permissible reservation that is either social, vertical or special, horizontal, opportunities to public employment and selection of candidates must purely be based on merit. Any selection which results in candidate getting selected against open general category with less merit than the other available candidates will certainly be opposed to the principle of equality. There can be special dispensation when it comes to candidates being considered against seat or quota meant for reserved categories, and in theory it is possible that a more material candidate coming from open general category may not get selected, but the converse can never be true. The converse can never be true and will be opposed to the very basic principle which have all while being accepted by this court. By introducing additional reservation for EWSs, the total number of seats for the open category would be reduced consequently. Open category is open to all the horizontal and vertical reservations, a method of ensuring representation in public places, and the right to equality of the person belonging to SCs, the STs, the SEBCs and BCs communities is impacted by reducing their seats in open category. The council
Where seems flexible rule that you can cross 50% down.
Sir, in Indraswamy it was said that this has to be taken extremely carefully, the 50% rule.
Where is it? Is there a provision in the constitution that you can't have any circumstances cross 50?
No sir, but this is in favor of the Indian state itself. Reservation has long been debated. The reservation is a long been debated topic, and as much as you increase it, it is very well said.
The idea of the 50% is to balance
Indeed,
the
Indeed.
different rules.
Indeed.
But it's essentially balance different rules. This 10% also form part of the 50%.
Sir, there is,
They've been identified based from the economic
Lordship,
factors.
that is the fact of this particular case. There is no group.
We
They are
can't
adding.
overlook a factor that India, predominantly in inhabited by different sources of view. It is to balance those. 50% have been over, the kind of 50% was movement. Essentially, this 10% comes part of the 50%. Again, it's balancing it.
Sir, that is what the contention, Your Lordship, is that what class? They have given a vague criteria that whoever falls in it will be a part of it. Reservation is a much concrete thing in the Constitution. It is not really, it is very fragile in its nature. It is very fragile for the country to deal with it. It has been long debated, and the philosophy itself states that it requires few grounds to be fulfilled. And in Indira's mind it was said, there should be some extraordinary situation at least if you are breaching the 50% cap. Where is the extraordinary situation?
Thank you.
Much obliged, Your Lordship. I would like to seek permission for my co-counsel to approach the dais. Much obliged.
Don't give permission to stand.
The council seeks permission to read a summary argument, which is given on page number 13. It's the memorial. Additional 10% reservation breaches 50% ceiling cap on reservation, hence violating of the basic structure of the Constitution. In Chandrasawari case, it was clearly decided that general limit in reservation is 50%. Hence, after this landmark given by the 9-judge bench, 50% ceiling cap was considered as a general rule. This general rule is upheld in various other cases after this judgment. Even before this judgment, in 1962, this court has said in M.R. Balaji case, flag number 6, page number 9 of the compendium, Justice P.V. Gajgandkar, para 34, said, and I quote, speaking generally in a broad way, a special provision should be less than 50%. How much less than 50% would depend upon the present prevailing circumstances in each case. This court always upheld the 50% general cap on the reservation. In only extraordinary situation, 50% ceiling limit can be exceeded. But in the present case, the petitioner doesn't see any extraordinary situation on the basis the 50% ceiling limit should be exceeded. By the way, 103rd Amendment has breached the 50% general rule set by this court, hence violating the basic structure of the Constitution.
So let us see what is the basic structure. Is the judgment of the court is the basic structure or could form part of the basic structure or constitutional identity?
Basically, basic structure defines the constitutional identity itself. And AWS, the classes created by the government,
That the numerical counting is it form part of the basic structure?
it depends upon cases to cases lordship here, that we have to see the case and the Bharti case itself to provide a basic structure. There should be a basic structure.
How do you formulate basic structure here?
If it stands with the constitutional principle, it stands with the constitutional identity.
Finally, word towards the basic structure. Now we say that numerical way of arithmetical way of calculating is form part of the basic structure.
So, lordship, if the anything which violate the constitutional identity, then we can clearly say it violate the basic structure of the Constitution. For example, in AWS reservation, they are not follow the intelligible differential, which the Article 14.
What Justice Vijendra Garan said that there can be extraordinary circumstances to cross 50% limit. What are those extraordinary circumstances?
Extraordinary situations when the proper data has to be committed. The AWS, the data has to be mentioned by the government is Sino Commission report. And I told here that what is the actual Sino Commission report?
It's not that. What are those extraordinary circumstances? Because you said this is a precedent, it should be confined to 50. If it cross 50, if there are extraordinary circumstances.
Yeah, we can cross 60-55 when the country present circumstances allows that 50, this need to be extraordinary situation in any circumstance which allows to any particular thing which qualifies and reflects the identity of the constitution. Here we have to see the exclusionary principle in itself. Then how can we say this is extraordinary situation itself, my lord? The council seek permission to advance argument issue number 3, which is given on page number 20 of the memorial. It is humbly submitted before this honorable court by providing enabling provision a maximum 10% reservation for EWS. The state is promoting compartmentalization. According to Cambridge Dictionary meaning, compartmentalization is given as the act of separating something into parts and not allowing those parts to mix together. In the present context, compartmentalization can be understood with the help of an illustration in itself. Let us suppose there are 100 seats in open government competition. 15 seats are reserved for the SC candidates, 8 seats are reserved for ST candidates, and 27 seats are reserved for the OBC candidates, which are already giving existing reservation benefited. The sum of this reservation turn out to be 50 seats, which is conformity with the 50% rule. Rest 50 seats are unreserved, hence open for every category in case of vertical mode of reservation. Whether the category reserved or unreserved, after the 103rd amendment, additional maximum 10% reservation is allowed for the EWS. Now suppose government gives 10% reservation for EWS besides existing reservation, that is, now sum of total of this reservation turn out to be 60, which is breaching the 50% ceiling cap, rule as laid down by the center itself. This is what compartmentalization in the present context. With the compartmentalization, the provision of reservation can later be understood as right to reservation. If this happens, then tomorrow various classes would demand reservation just on the basis of right to reservation, even if the purpose of reservation, that is uplifting the backward class to the mainstream society, is fulfilled and achieved. Plus, there is no right to reservation in the constitution. Hence, by enabling provision for additional 10% reservation, not only violate the 50% ceiling cap, but also a sense of compartmentalization can be felt here, Lordship. The council permission to summary argument issue number 4. Which is given on page number 13 of the memorial. Giving reservation solely on the basis of economic criteria is a violation of the basic structure of the Constitution. Nowhere in the Constitution there is explicit provision to be given on the basic economic criteria. Even in Chandra Sauli case, we have witnessed under that this court upheld the elimination of the creamy layer, that is, socially advanced person is a backward classes. Court clearly held that creamy layer cannot be excluded solely on the basic economic criteria unless the economic advancement is so high that it necessarily means social advancement. In short, economic criteria can only be taken as secondary criteria. The primary criteria is social backwardness, a social class. Hence, giving reservation solely on the basic economic criteria is a violation of the basic structure of the Constitution.
What is the idea of cream layer in school? Idea behind the rationale behind cream layer.
The idea behind, because they are social forward class, means they are capable of the means of livelihood they fulfill.
Socially,
Social forward class, they would not have considered as a backward class. This is it, layer would apply to executive, socially backward class. Not with respect to forward class.
The council advance issue number 4.
What is the answer to this? Question was, why should there be a creamy layer concept even among the socially and educational backward classes?
In the SCBC reservation, we are giving the creamy layer reservation. That's the question, Lordship. Okay. Basically, we know that the something income criteria we have to fix it. That apart from this below, you have to fulfill the criteria, then you will get benefit. When you cross this criteria, then you will be excluded from the benefit of the reservation itself.
Why it is done is the question.
Why it is done?
it's not done in SC/ST.
Because SC/ST has felt a historical depression. They are not adequately represented for whatever manner they are giving a reservation. The main object of reservation is a reparation in itself. But here, we can't give a reservation because Article 46 of the Constitution itself says promotion of educational and economic interest of scheduled caste, scheduled tribe and other weaker section. The first, we don't have a problem to give other weaker section, you can interpret it. But you can't exclude the SC/ST here. You have to follow in the mind of DPSP in itself while you making any law in itself. Here you can clearly violate 46, means it is directly related to the Article 14 of the Constitution. Means Article 14 is violated, it's clearly related to the basic structure of the Constitution. Hence, the identity of the Constitution itself damages violation.
Which chapter do you get Article 46?
This is part 4 of the Indian Constitution.
How is it justiciable?
It is not just here, but the state can take into consideration while making any law itself. Issue number 4 of advance argument, page number 21 of the memorial. It is humbly submitted before the court that reservation is always for homogeneous class and people identified as EWS do not form homogeneity. For affirmative action, a class must be identified so that particular class must get benefit of affirmative action, that is reservation. Class must have homogeneity in it to get benefit under reservation. An observation made in all Assam retired officer, teachers, employees committee and others was in the state of Assam and others, which is given on compendium page number 33, flag number 25, para 23, and I quote, Article 14 is attracted when equals are treated differently without any reasonable basis. Article 14 permits reasonable classification, but the classification must satisfy the twin tests of classification being founded on intelligible differentia. The two conditions which I write here. The classification must be found on intelligible differentia which distinguish person or things that are grouped together from others left out of the group. Second one, the differentia must have a rational relation to the object sought to be achieved by the Constitution, which is given on flag 26, page number 16. Intelligible differentia as a concept arises from Article 14 of the Constitution, which allows the state to form groups on reasonable basis to provide them certain benefits. Here, it is noted that the group of EWS formed by the government doesn't form the homogeneity because this group has been formed on the economic basis. Economic criteria is a transient, temporary, and rather than dispensable group. In an individualistic characteristic, for example, today a person X may come into the category of EWS, but after 3 years, once his income is increased more than the prescribed limit, then he will be excluded from the EWS category. Hence, EWS section is very temporary in nature and does not allow and does not show any traces of historical discrimination. Traces of historical discrimination can be seen in other classes like SC, ST, OBC. Even though EWS may show some traces of historical discrimination, but still the intensity of such discrimination is not so high, justify the reservation. If there is no homogeneity in a group, then it can't be called a group at all. And if no homogeneous group, then government cannot do a reasonable classification. And if reasonable classification or intelligible differential is not done, then government can't justify herself in giving unequal treatments to the unequal. Hence, government would violating the Article 14 of the Constitution by having no intelligible differential while creating the class of EWS. The Council moves to the 4.2 advance argument. It is humbly submitted before this court that economic criteria cannot be determined for backwardness or weakness of class. An observation is given at M. Nagaraj and others versus Union of India and others, flag 27, page number 35, para 120, say, and I quote, at this stage, one aspect need to be mentioned. Social justice is concerned with the distribution of benefits and burdens. The basis of distribution is the area of conflict between rights, needs, and means. These three criteria can be put under two concepts of equality, namely formal equality and proportional equality. What is formal equality? Formal equality means that law treats everyone equal. Of egalitarian equality is the concept of proportional equality that accepts the state to take affirmative action in favor of disadvantaged section of the society within the framework of the democratic polity. In Indra Swani, all the judges except Justice Pandan held that means test should be adopted to exclude the creamy layer from the protected group earmarked for the reservation. In Indra Swani, this court has therefore cast as a determinant of backwardness, and yet it has struck a balance with the principle of secularism, which is the basic feature of the constitution, by bringing the constructive media. Views are often expressed in this court that caste should be determinant of backwardness and economic criteria alone should not be determinant of backwardness as stated above. We are bound by the decision of Indra Swani taken as a consideration while making anything as stated above, that determinant of backwardness cannot go beyond us in binding decision. In addition to the above requirement, this code in Indra Swani has evolved numerical benchmark like ceiling limit 50% based on post-specific roster coupled with the concept of replacement to provide immunity against the charge of discrimination. As clearly stated above, the economic criteria cannot be determinant of backwardness. In the 103rd Amendment, the only determinant of backwardness EWS economy, which is against the binding decision of this court in Chandra Saveri. If question of determinant can't be gone into by this court in view of the binding decision, the state should also respect the decision of Indra Swani. Hence, EWS, which is being determined solely on the basic economic criteria, is unjustifiable, is going against the court. One of the judgment in Janaki Prasad Parimo was the state of Jammu and Kashmir, AIR 1973. The court observed that poverty alone cannot be test of backwardness in India because by and large people are poor, and therefore large section of population would fall under the category and that the whole object of reservation would be frustrated. The council will move to the 4.3 advance argument. It is humbly submitted before this honorable court. There is no rational relation between the object short and the object short for the class BWS. The statement and object short for the introduction of Constitution 124. While giving reservation, we take into consideration of social upliftment in itself. And economic criteria, we can first we have to state a first stage. We can give us some measures, alleviation scheme. Reservation is not a poverty alleviation scheme, my lordship. So many schemes are there. We can give a scholarship, we can give a scholarship, we can give something allowances for them, for uplift to getting education, job, anything. But we can't give a reservation. The object of reservation, if we give to of this class, various classes would emerge in the future also, then the object of reservation would be automatically frustrated in itself. We have witnessed in the Maharashtra itself how this can happen when the state government gave Maratha community a reservation. Supreme Court is struck down. Say that this is
the idea of a society always change, not constant. Those times, economic parameters are very less. Economic dimensions or dynamics are very less. So social upliftment is in a market economy where the GDP is the factor to measure the growth, and economic ideals are spread out in the affairs of life, then those who have no means, they will be marginalized by factors in the the society. That's exactly the reason those factors will stand in his way of moving forward. This exactly happened to the social group. Some other factors, the foreign elements, always stand against them for moving forward. Similarly, in a liberalized economy, from post-90 onward to find the economic factors are determining anything in the land.
indeed, lordship.
That criteria, the economic poverty also become a factor also, and will stand as a hurdle against moving forward.
Indeed, my lordship. The AWS government is providing a reservation. The basis of reservation they are providing a Sino Commission report. And I quote here the Sino Commission report itself. As per per the Commission report, Niti Aayog multi-dimensional poverty index, the background class poor are poorer than the upper class poor. It is stated that economic criteria would not result homogeneous class. The statistics.
See that when was the US and was entered? When was it?
In this one in 1992, Lordship.
92. See, look at the social structure that was prevailing in those times. And now we are in 2023.
Indeed, Lordship.
When was Sino Commission? 2000. When was the Sino Commission?
2010.
2010.
Yes, Lordship.
You were basing on 2010.
Yes, Lordship. Because the government providing EWS reservation on the basis of these facts. The Zero Commission has submitted its report and the Pandey Commission in itself. The two commissions are itself saying that the SC, ST are poorest among the poor in itself. Then you can exclusionary principle you have inserted it, it's violating of the basic structure of the constitution.
Reservation itself is a temporary measure, was thought of as a temporary measure, not for all times to come. Because the idea is you should have an egalitarian society where there is classes as classes. You can't think of this as a measure which is going to last forever. Reservation.
Indeed, my lordship. Here we are very well aware with the fact that reservation is only for temporary measure, but these castes are in right now even also after 7 decades in the Republic of India, we have witnessed they are not adequately represented for what the constitution maker wants at that time. They are giving reservation for temporary 10 years.
It's a scenario where an affluent and backward community which was very affluent and still eligible for this and those who are who happen to be born in a particular caste or community have no other means of education, no other means. Now, how do you balance these conflicting interests in the perspective of the state?
Reservation I have already contained. Reservation is a reparation. The class you are talking about, lordship, is that we can do for social upliftment. We can various schemes we can introduce in itself for upliftment to the community, the mainstream society. But SC, ST for the exclusion of the violative code, it is not justifiable in itself.
Constitutional untouchability and all now central level has managed to come down. Though it may exist in some form, it is that was those factors stood against the social identified groups. Those are gone.
How many generations are you going to give this?
Until the social upliftment, until the social upliftment take place, until they adequately represented what the constitution maker wants to them for the particular post, any jobs, education sector, they represented in a proper manner. Then we can have only because we know that India is a dynamic country in itself. We have a different religion, faith, communities, and day by day population are increasing. 4.4 advanced argument. It is humbly submitted before the court that impugned amendment, the state has given the sole importance of economic disadvantage rather than social and educational backwardness. Explanation under 15 clause 6 reads as under, for the purpose of this article and article 16, economically weaker section shall be such as may be notified by the state from time to time on the basis of family income, other indicators of economic disadvantage. Here we can clearly see that economic disadvantage has been given the most important where there is no such mention of social and educational backwardness. An observation in Chandra Sauri, Justice R. Ratnavel Pandyan, flag number 31, page number 6 of the compendium, para 1 and 19 said, and I quote, the degree of importance to be attached to social backwardness is much more than the importance to be given educational backwardness and economic backwardness. Because identifying and classifying a section of people as a backward within the meaning of Article 16.4 for the reservation of appointment of post or social backward plays a dominant role. Educational backwardness can be taken into consideration for the purpose of Article 15.6 because Article 15.6 state can provide reservation in education itself. The council proceed with the prayer. In the light of issues raised, argument cited, authority cited, the counsel for the petitioner humble praise before the honorable court to please adjudge and hold and declare that there was an error in the face of record while delivering the judgment before this review petition. Hence, the said judgment is being reviewed by this court exercising the power under the Article 137 of the Constitution of Nepal. First one. Second, the 100 amendment by explicitly excluding SC, ST and SCB, the NPC from the definition of AWS is actually violating the Equality Code enshrined in the Constitution from Article 14 to 16. The 103rd amendment can be said to breach of the basic structure. Point number 3. The 103rd amendment by enabling maximum 10% reservation for AWS beside the existing reservation violates 50% ceiling limit rule on the reservation set by this court in various cases. There is no extraordinary situation in the present case, so that 50% ceiling limit shall be breached. Hence, 103rd amendment can be said to breach the basic structure of the Constitution. Last, the 103rd amendment by incorporating a provision to determine the AWS solely on the basic economic criteria violates the basic structure. Economic criteria disadvantage can be criteria to determine economic criteria, other criteria. Social criteria shall be taken into consideration by determining the AWS, and pass any order that this honorable court may deem fit in the interest of equity, justice and good conscience. Much obliged, Moot.
The council seeks the permission to approach the debtors. Much obliged.
Greetings to the Honorable Bench. If it may please, the Council seeks the permission to address the bench as your Lordship. Much obliged, Your Lordship. The Council is appearing before the Honorable Court in the matter of Akka Khan versus Union of Mewar on behalf of respondent in response to the petition filed by the petitioner under review jurisdiction of this Honorable Court. Your Lordship, there are 4 main issues involved in the present case. The Council will be dealing with the first and second issue, and the Co-Council will be dealing with the third and fourth issue. The Council seeks the permission to begin with the statement of facts. Much obliged, Your Lordship. The Constitution of Mewar is a sacrosanct document whose cardinal principle is right to equality. However, reasonable classification and reservation to underrepresented categories of citizens through affirmative action policies, including quotas, was permitted under the Constitution. In 2019, the Constitution 103rd Amendment Act was introduced, which enabled a 10% reservation for economically weaker sections of citizens who are not a part of the scheduled caste, scheduled tribe or non-creamy layer of other backward classes. Several cases were filed challenging the amendment's constitutionality, and a 5-judge constitution bench of this Honorable Court heard the matter and delivered 4 separate judgments, with 3 upholding the amendment and 1 dissenting. Constitution 103rd Amendment Act 2019. Bill number. Much obliged, Your Lordship. The petitioner in the above case, Akka Khan, files his review petition containing error apparent on face of record. If Your Lordships are now familiar with the facts, the Council seeks the permission of this bench to proceed with the first issue. Much obliged, Your Lordship. My Lord, the first issue is whether the review petition is maintainable or not. My Lord, the review jurisdiction, as Your Lordship knows, is a power conferred by the Constitution and the rules framed thereafter.
What is scope according to the what is scope of review according to?
My Lord, according to scope of the review, in Supreme Court Rules 2013, it is given that it is according, in a civil case, it is according to the Order 47 in the Code of Civil Procedure, and there are 3 conditions that are given in the Code of Civil Procedure in
They
all.
say that we all know the binding precedent of Indo-Islamic studies. Large operation.
My Lord, the principle of stare decisis is a principle that has been enunciated with a view to keep the consistency and uniformity of
Tell
decision.
us how that arbitrary going to be. They say that we all know binding precedent.
My Lord, the binding precedent, my Lord, the principle of stare decisis has no rigid application as in the case of res judicata. And my Lord, there is no contention from the petitioner that the judgment was not brought to the notice of the Honorable Court during the hearing and the judgment has been overruled. It is a settled position of law that when a matter has has been considered and the decision is rendered after such consideration, there is no error apparent on the face of record.
That's correct. But how do you meet this argument? What was decided in trustwise case?
Milord, the council put forward that there is no violation of the Indira Savani judgment. And for that, what the council would like to substantiate that the facts of the Indira Savani case was that it was actually, in that case, this Honorable Court was checking the constitutional validity of an office memorandum which was given by the government with the then provisions existing in the constitution for reservation. At that time, there was no provision which allows economic reservation. And on basis of that, the said office memorandum was struck down. And whatever other than that, the other observations made by this Honorable Court in the Indira Savani judgment would only constitute the obiter dictum and would not constitute the ratio decidendi.
Just tell us what is the difference between obiter and decision.
Milord, only the ratio decidendi part of a judgment will be binding on this Honorable Court and in other and has only the precedential value. The obiter dictum is actually the observations made by the court and it has no precedential value. It may or
How do you distinguish the same in the context of Indira Savani's case?
Milord, in the Indira Savani case, the fact was that whether the office memorandum was constitutional or not with the then existing provisions of reservation given in the constitution. And the observation and the ratio decidendi was that with the then existing provisions, reservation based on economic criteria cannot be given. That constitutes the ratio decidendi. But now the question before this Honorable Court is whether this constitutional amendment is valid or not. The other one is validity of an office memorandum, and here it is a constitutional validity of an amendment.
Okay.
Much obliged, Your Lordship. Lord, it is humbly submitted that the review petition filed before this Honorable Court is not maintainable, which the Council would be establishing on 3 grounds. There is no discovery of new and important matter or evidence in review application, there is no mistake or error apparent on the face of the record, and there is no other sufficient reason to entertain the review petition. With permission, moving on to the first ground. But there is no allegation in the petition to the effect that there was any new fact or evidence which could not be produced at the time of hearing by the review petitioner. Therefore, the review cannot be maintained under the ground of discovery of new and important matter or evidence which after due diligence could not be produced. The judgment has been delivered taking into consideration all the contentions advanced by the contesting parties. In such circumstances, the review cannot be maintained on the ground of discovery of any new and important matter or evidence. As is evident from the pleadings, the grounds urged were contested before the Honorable Court and no new materials were placed so as to canvass the ground of review. Now the second ground is that there is no mistake or error apparent on the face of record. The review of judgment is sought mainly on the ground that the larger bench decision has not been considered and the upholding of the amendment violates the basic structure of the Constitution. It is submitted that the larger bench decision has been considered while passing the judgment under review. There is no contention that the judgment was not brought to the notice of the Honorable Court during the hearing and the judgment has been overlooked. It is a settled position of law that when a matter has been considered and a decision is rendered after such consideration, there is no error apparent on face of record. This Honorable Court in Meera Bhancha vs. Srimati Nirmala Kumari Chowdhury held that the error apparent on face of record means an error which strikes on mere looking at record and would not require any long-drawn process of reasoning on points where there may be conceivably be two opinions. As is evident from the pleadings, no error on mere looking of record has been pointed out. The larger bench judgment, which according to the petitioners not properly considered while passing the judgment under review, cannot be construed as an error apparent on the face of record. There is a clear distinction between delegation of an erroneous decision and an error apparent on the face of the record. The grounds urged by the petitioner is mainly on the premises that the judgment rendered is an erroneous judgment inasmuch as a larger bench decision has not been properly considered or the law laid down by the larger bench decision has been varied. The said contentions are not an error apparent on the face of record. The grounds urged in the petition seeking review is in fact grounds for rehearing of the case on merits. The law has been settled in this regard by the Honorable Supreme Court in another Reddy versus in Anshu Kataria that review jurisdiction is not an appeal in disguise. The review does not permit rehearing of the matter on merits. With permission, moving on to the third ground that there is no other sufficient reason to entertain the review petition. The Honorable Supreme Court has considered the meaning of the term any other sufficient reason in More and Mar Basilius Catholicos and another versus Most Reverend Mar Paulus Athanasius and others, and held that any other sufficient reason must mean a reason sufficient on ground at least analogous to those specified in Moot. As stated above, there are no grounds for reviewing the judgment pleaded in the review petition. Therefore, there is no sufficient reason to review the judgment. In Lily Thomas and others versus Union of India and others, it was held that the power of review can be exercised for correction of a mistake, but not to substitute a view. The review cannot be treated like an appeal in disguise, and the mere possibility of two views on the subject cannot be treated as a ground for review. In Kamaleshwar versus Mayavadi and others, it was observed that review proceedings have to be strictly confined to the much obliged, Your Lordship. The Council seeks the permission to move to second issue. My Lord, the second issue is whether the review petition filed before this Honourable Court is made in error of law. The review petition is filed on the premises that the Constitution Bench judgment in Chandra Saveri case has not been considered and the judgment under review is against the law laid down by the Constitution Bench. The contention in the review petition that the Chandra Saveri case is not considered in the judgment under review is factually not correct. The content. My Lord, by Constitution Bench here, I meant the Constitution Bench in the
What matters for a bench is a constitutional bench, in other is not a constitutional bench.
My Lord, in Chandra Saveri case,
When you got a decision rendered by Constitution Bench, not rendered, obviously, how do you distinguish when you see a judgment, how do you call it as a bench? Constitution Bench decision.
My Lord, the bench was of 9 judges and the matter was regarding the constitutional provision.
So if there are 9 judges, you call it a constitution bench?
No, my Lord, I never said that, but the issue was regarding a constitutional matter.
And any matter before Supreme Court invariably accept matters related to appeal like the criminal procedure or matters being dealt under the Constitution.
Moreover,
Call a bench as a often we hear this Constitution bench,
my Lord, the Honorable Court has the jurisdiction to hear on the constitutional
We are
matter.
also hearing the High Court as a Constitution.
And even 2 judges can.
Yes, my Lord, High Court and Supreme Court are constitutional benches.
No, don't call it Constitution. We are not calling it Constitution.
This Honorable Court is apex court, my Lord.
In which case all judgments are the experts of the constitution.
In cases regarding the constitutional validity of an amendment,
We hear the norms that rule the division in Constitution, large things. It is often something like justice could come to the court, judgments as a single bench, division, court bench.
single bench is when one judge is hearing the matter, and the division bench is when more than one judge is hearing the matter. When it is a constitutional bench, if I don't know if I am correct, it is actually 5 bench judge is what the constitutional bench is. Much obliged, Your Lordship. The contention that the Chandra Saveri case is decided by larger bench and it is binding and it cannot be deviated is also legally not correct. It is humbly submitted that the judgment under review was not made in error of law, which the Council would be establishing on 3 grounds. Firstly, the judgment under review does not violate larger bench decision in Chandra Saveri case. Secondly, there is no violation of dictum laid down in Chandra Saveri case. And thirdly, the reservation based on income is permissible under directive principles of state policy. With permission, moving on to the first ground. My Lord, the principle of stare decisis is a principle enunciated with a view to keep consistency and uniformity of decision, but it has no rigid application as in the case of res judicata. The principle of stare decisis is flexible. It may be noted that the Chandra Saveri case, or rather the principle laid down in the case, has been deviated by this Honourable Court in Ashok Kumar Gupta was the state of UP, a judgment delivered by a bench composed of 3 judges. In the said judgment, it has been held that the rule of stare decisis, though one tending to keep consistency and uniformity of decisions, is not an inflexible rule. Whether it shall be followed or departed from is a question entirely within the discretion of court, and it does not deter the court to depart from it. Stare decisis is not like the rule of res judicata, a universal inexorable command. Whether it would be desirable to continue the decision in constitutional question is one of the choices between competing rights. In the judgment under review, the larger bench decision has been pressed into service and has been elaborately dealt with in the judgment. The reason for deviating have also been concluded. In such a situation, the contention that the larger bench decision has not been considered is not correct, and it cannot be held that there is any error apparent on the face of the record in the judgment under review. My lord, the contentions with respect to the dictum laid down by the Constitution bench in Chandra Saveri case is also not correct. It is important to notice that at the time when the Chandra Saveri case was considered by this honorable court, there was no provision in the Constitution for reservation based on economic condition. On that premises, this honorable court has struck down an office memorandum issued on strength of the then existing provision for reservation implementing economic reservation. Therefore, the factual metrics in both the cases are under review are entirely different. In the judgment which is sought to be reviewed, the honorable court was dealing with the issue of constitutional validity of the amendment brought into the Constitution. My lord, therefore, the contention the review petition are misplaced and deserving it to be rejected. Article 137 of the Constitution of Mewar specifically empowers this court to review any judgment pronounced or order made by it subject to the provision of any rules made under Article 145. The review power has been detailed in Order 47, Rule 1 of the Supreme Court Rules 2013. The principle of review has been dealt with in the Code of Civil Procedure in Section 114, Order 47. There is a catena of decision dealing with the powers of review and the circumstances under which a review can be entertained. The principle enunciated can be safely concluded with respect to error apparent on face of record as an error which is easily identifiable on bare reading of the judgment without any further reasoning. The main ground urging the review to canvass error apparent on the face of record is an alleged deviation or rather overruling of the larger Constitution bench decision. As submitted above, the larger Constitution bench decision has been considered by this honorable court while passing the judgment. It is not a case of silence or not bringing the decision to the notice of the court while passing the judgment. In such circumstances, the contention in the review petition with respect to the error apparent on the face of record cannot sustain legal scrutiny. The alleged error apparent on the face of record requires a further hearing on the merits of the case and then to find out further reasoning, which is impermissible under the provision for review. Therefore, it is humbly submitted that there is no valid ground to review the judgment and the petition only deserves to be dismissed. The second ground is that the judgment under review does not violate the dictum laid down by this honorable court in Chandra Saveri case. This honorable court has summarized the answers to the various questions dealt with in the Chandra Saveri case, and it has been specifically held that a backward class of citizens cannot be identified only and exclusively with reference to economic criteria, but it is of course permissible for the government or other authority to identify a backward class of citizens on the basis of occupation cum income without reference to caste if it is so advised. Therefore, it can be safely concluded that the classification on the basis of income without reference to caste as done in the Constitution 103rd Amendment Act 2019 is not in violation of law declared by this honorable court in the larger bench decision. The allegation of rule laid down in the larger bench decision with respect to the reservation to the extent of 50% only is also misplaced. The larger bench was deciding on the issue of reservation under Article 16 clause 4 only, and at that premises it was held that the reservation should not exceed 50%. But at the same time it has been held that where 50% shall be the rule, it is necessary not to put out of consideration certain extraordinary situations inherent in the great diversity of this country and the people. In these circumstances, the legislature has got the absolute power to decide on the extent of reservation, taking into consideration various parameters and the needs of the society. The review cannot be entertained on this ground as well, requiring it only to be rejected. And the third ground is reservation based on income is permissible under the directive principles of state policy. It is a basic principle of law that an organic and not pedantic approach to interpretation must guide the judicial process. The constitutional validity of an amendment to the Constitution has to be considered on the harmonious healing interpretation. The legislature is a competent authority to decide on what the society needs. The reservation on the basis of income has been decided by the legislature, taking into consideration all parameters and finding it necessary to provide reservation to the economically poor for their upliftment and participation in social engineering. Article 38 of the Constitution of Mewar provides that states shall in particular strive to minimize the inequalities in income and endeavour to eliminate inequalities in status, facilities and opportunities. Therefore, it is within the domain of the Parliament to make an amendment to the Constitution incorporating provision for reservation of economically backward class. The amendment cannot be held to be violative of directive principles of state policy. The amendment cannot be said to be violative under the guise of Article 46, contending that the reservation can only be with respect to social backwardness. Eradication of economic inequality is also one of the prime goals of the Constitution. There is no violation or deviation from the directive principles of state policy. The judgment has been delivered considering all the aspects of social engineering and the provisions of the Constitution. There is no error apparent on the face of record, discovery of new fact or any other sufficient reason to review the judgment. The review petition is only experimental and is in fact filed as an appeal in disguise, impermissible under law. The review petition only deserves to be dismissed. Your Lordship, unless the court has any further question regarding the submission, counsel wishes to call upon the full counsel for presenting the third and fourth issue. Much obliged, Your Lordship. It was a pleasure to be before this honorable.
Council seeks permission to approach the dais. Much obliged.
Thank you, Counsel. Honorable greetings to the bench. This is Counsel number 2 appearing on behalf of the respondents in the case of Akka Khan versus Union of Mewar. The Council will be dealing with the third issue, that is whether the amendment violates the basic structure doctrine, and the fourth issue relating to the fixation of income ceiling as arbitrary and thereby violative of Article 14. The Council seeks permission to present the third issue, Your Lordships. Much obliged, Your Lordships. Your Lordships, the third issue is in regards with whether the Constitutional Amendment Act of 2019 is violative of the basic structure doctrine. It is humbly submitted before this court that the Constitutional Amendment Act of 2019 is not violative of the basic structure doctrine, and this issue shall be dealt in a fourfold manner. Firstly, the Constitution is a living...
You have a mobile with you?
Indeed, no, Your Lordships. Apologies, Your Lordship. The council seeks permission to move on. Much obliged. Firstly, the Constitution is a living document. The living metaphor of the Constitution of Mewar has relied significantly from the jurisprudence of Canada and United States, Your Lordship. In the case of State of West Bengal versus Anwar Ali Sarkar, Justice Vivian Bose indicated that it was challenging to interpret constitutional provisions without regard to the background out of which they arose, because they were not just dull, lifeless words, static and hidebound as in some mummified manuscript, but living flames intended to give life to a great nation and order its beings, tongues of dynamic fire, potent to mold the future as well as to guide the present, Your Lordships. The court used the living metaphor to determine the amending powers of the Parliament in the case of Keshavananda Bhati versus Union of India as well. The court ruled that as long as the basic structure of the Constitution is intact, the Parliament may make changes to the Constitution, including the fundamental rights. Justice Y.V. Chandrachud in the above mentioned case has stated that Constitution is a living organism which evolves to suit the history and genius of the nation. The living metaphor was used to justify the goal, which is to strengthen the Parliament's constituent authority in order to ensure the Constitution's flexibility, Your Lordships. In the case of Kapila Hindurani versus State of Bihar, the court found it well established that the constitution of the country was a living organ that called for changes as...
Given the precedents, let us know why they said that.
Indeed, Your Lordship.
Justify is not a case of basic structure.
Indeed, Your Lordship. The council was just trying to make the point that the amendment was made as the changes to meet the changing needs of the society, Your Lordship.
Tell us how.
Yes, indeed, Your Lordship. Secondly, the insertion of EWS class is a valid category, Your Lordship. The right of the EWS category derives its strength from Article 21 of the Constitution, which guarantees the right to dignity as poverty adversely affects the dignity of an individual, Your Lordships. It is argued that the state has a duty to end poverty in order to ensure economic justice through a number of international obligations, including the Universal Declaration of Human Rights and the International Covenant on Economic, Social and Cultural Rights, which are covered by Articles 46, 51C and 253 of the Constitution, Your Lordships. In this regard, the amendment in question becomes an empowering measure for those who are suffering from systemic poverty, Your Lordships. It is humbly submitted that the inclusion of the EWS category is a valid class for the expansion of special measures for their advancement, enrollment and for reservation in posts. It is argued that a variety of state-introduced policies such as housing assistance, admission to hospitals or schools, etc. have also recognized the classification of people according to their economic criteria. Furthermore, this honorable court has regarded poverty as a sign of backwardness when it considered reservation in various cases such as M.R. Balaji versus State of Mysore and R. Chitralega and another versus State of Mysore, Your Lordship.
In such cases, it's not
Indeed, Your Lordship, there
Why
are...
that reservation?
Indeed, Your Lordship. The schemes and policies that are now existing are still not helping the poorest of the poor communities and apologies, Your Lordship, the poorest of the poor sections in the society, Your Lordship. Which is why the government found it necessary to bring in this amendment, to bring it as a reservation, Your Lordship. The poorest of the poor sections of the society have been existing for a very long time, Your Lordship.
What level this reservation should operate in such circumstances?
Your Lordship.
Just to empower, you said this empower.
Indeed, Your Lordship.
You should have some nexus with object.
Indeed, Your Lordship.
What level that reservation should operate?
You-
Functional.
Your Lordship, the criteria for the reservation will be dealt in the next issue. If Your Lordship's mind,
We can
much obliged. The Council seeks permission to move on with this issue.
yes.
Much obliged. It was held in Waman Rao and others versus Union of India that it is impossible for any government, however expertly advised, socially oriented and prudently managed, to remove every economic disparity without causing some hardship or injustice to a class of persons who are also entitled to equal treatment under law. That cannot, however, furnish an argument for assailing the improved laws on the ground that they violate the guarantee of equality, Your Lordships. The exclusion of SC, ST and OBC communities is lawful since it affects the classes rather than the castes that are already eligible for special benefits, Your Lordship. Moreover, these communities, these SC, ST and OBC communities are already receiving reservations, and for giving them further reservations will only amount to double benefit, Your Lordships. Thirdly, there is no apparent violation of the basic structure, Your Lordship. The 103rd Amendment does not violate the basic structure doctrine of the Constitution, rather fosters it. The exclusion of the SC, ST and OBC communities already covered under Article 15 Clause 4 and
You said the scheduled caste community is already benefited by the solution. Then again, including them. See, this is horizontal reservation.
Indeed, Your
That
Lordship.
means that will reduce the opportunity for the scheduled community in a sense.
Indeed, Your Lordship. Your Lordship, however, the reservation that is being received by the SC, ST and OBC communities are irrespective of their economic criteria, Your Lordship.
That's correct.
Yes, Your
But
Lordship.
when you with horizontal reservation, what would happen? That will reduce the sphere of opportunity for the scheduled caste in that larger quota of 50 according to you.
Your Lordship, it is the 10% reservation that has been kept for the EWS categories apart from the 50% reservation that is kept for the SC, ST and OBC communities, Lordship. It is not even directly affecting the 50% reservation that is kept for the SC, ST and OBC communities, Your Lordship.
Yes.
Much obliged, Your Lordship. Your Lordship, the present amendment does not violate the basic structure doctrine.
So why should the CSTs be kept out of the 103rd Amendment? Only 50% seats are reserved.
Indeed, Your Lordship.
Why should the 16th ban? Why should it be deprived if his income is below or if it is same as the EWS? Why should he be kept out?
Your Lordship, the Council would like to reiterate the fact that SC, ST and OBC communities are currently receiving reservations.
Every 15%.
50%. Yes, Your Lordship. Apologies, Your Lordship.
It includes the SC, the ST as well as the CBC, OBC.
Indeed, Your Lordship. Your
It
Lordship.
is not for the SC alone.
No, Your Lordship. Indeed.
So only 15% of the members of the SC are getting it.
Indeed, Your
What
Lordship.
about the 85% if they still fall under the income limit fixed for the EWS?
Your Lordship, these communities that are getting reservation are getting despite of their economic criteria, Your Lordship. Even if they are economically well off, they are getting these reservations just because of the fact that they belong to a particular community, Your Lordship.
They also sometimes constitute a predominant community. They have largest vote.
Indeed, Your Lordship.
So that continue to otherwise benefit by economic criteria, maybe are forming in a lesser group. So they will be in an advantageous position, march over others.
Indeed, Your Lordship. However, the present scenario is that the reservation being received by these communities are irrespective of any economic criteria. Even if they are well off, Your Lordship, they are not being excluded from this reservation just because of the fact that they belong to this particular caste, this particular community, Your Lordship. However, the present amendment tries to bring in reservation for the poorest classes, for the poorest of the poorest sections of the society, Your Lordship, just so that they can also be equally represented in the state, Your Lordship. The Council would like to further submit that, Your Lordship. Apologies, Your Lordship. Yes, Your Lordship. Indeed, Your Lordship. Your Lordship, even in the general category, even within the upper caste, Your Lordship, there are a percentage of people who are economically poor, Your Lordship, and
That's not my question.
indeed, Your Lordship. Indeed, Your Lordship.
They control maximum number of questions.
Indeed, Your Lordship.
Private segment, government.
Nucleus of larger population.
Yeah.
Apologies, Your Lordship.
See, when you look at the statistics,
Indeed, Your Lordship.
the upper caste people, socially who had an advantageous start in their life, they hold maximum number of posts. When you compare the percentage,
Indeed, Your
the
Lordship.
upper caste people, they hold maximum number of posts.
Indeed, Your
So how do you correlate this?
Your Lordship, the reservation that is brought in for SC and ST is so that a percentage of seats can be reserved for them so that they can be represented, Your Lordship. However, the Council would like to put forth that even in the general category, even among the upper caste, there are poorer sections who are still not represented in the state, Your Lordship.
What is the criteria of this EWS?
Your Lordship, the Council will be coming to that. If if the court permits, the Council can move on to the next issue and much obliged, Your Lordship. Your Lordship, the fourth issue is regarding the fixation of income ceiling and how it is not irrational and not violative of Article 14 of the Constitution. Firstly, it is humbly submitted that there is no arbitrariness or unreasonableness in the determination of the economically weaker section, and the same has been arrived at by relying upon sufficient data, Your Lordship. Reservation on the basis of economic criteria is the need of the hour and the stepping stone to achieve economic and social justice, moving away from caste-based reservations, Your Lordship. The terms of reference of the Sinhu Commission included criteria suggestion for identification of economically backward classes and to elicit views of state government, union territories and other commissions on the subject. Much obliged. The methodology adopted by the Commission includes collection of information from all the states and union territories through a comprehensive questionnaire, Your Lordships. It had conducted various surveys listed from clause 1.7 to 1.9 of the report. It also held discussions with officials, members of the media and social activists in order to analyze the economic backwardness and communicated with leaders of social scientific institutions and held workshops and seminars before determining the economically weaker section as well as the quantum of reservation. Thus, it is humbly submitted that the data collected by the Commission is sufficient and could be relied upon. Furthermore, the definition of economically weaker section as under the explanation of Article 50/6, quote unquote, explanation, for the purpose of this article and Article 16, economically weaker sections shall be such as may be notified by the state from time to time on the basis of family income and other indicators of economic disadvantages, Your Lordship. An EWS category or a person belonging to an EWS category would be one having annual household income below rupees 8 lakhs, agricultural land below 5 acres, residential house below 1000 square feet, residential plot below 100 yards in notified municipality, and residential plot below 200.
5 lakhs is criteria.
Apologies, Your Lordship.
5 lakhs is the criteria.
8 lakhs, Your
8
Lordship.
lakhs.
8 lakhs, Your Lordship.
8 lakhs is the criteria. So then those who have some 8 lakhs,
Yes, Your Lordship.
ceiling upper ceiling is 8.
Yes, Your Lordship.
They may get the benefit of reservation. In particular circumstance, suppose for example, an admission to a college,
Yes, Your Lordship.
the person who is having 8 lakhs income, who scored 63 marks, they get admission.
Indeed, Your Lordship.
But there is a case, suppose the annual income of 50,000, he scored only 55% mark.
Indeed, Your Lordship.
Those who have an advantage in the financial circumstances march over those who are living in a more perilous circumstances.
Your Lordship, the income.
So there is no creamy layer in this.
Your Lordship, the income ceiling that has been kept, that is.
Should I ask?
Yes,
There is no
indeed.
creamy layer in this.
Indeed, Your Lordship.
Those who have an 8 lakh, assuming LLB admission, economically bachelor of commerce company, he scores 63% marks and seeks an admission. The annual income is 8 lakh. Another candidate scored only 55% and marks is 55%. Income is 65,000 rupees. There is no creamy layer within this.
Your Lordship, the income ceiling is not the only and sole criteria by which.
Exactly. And income is the only criteria here.
No, it is not the sole criteria, Your Lordships. The Council has mentioned.
What is the other criteria?
Your Lordship, the council will be mentioning it again that not just 8 lakhs, but agricultural land below 5 acres, residential house below 1000 square feet, residential plot below 100 yards in notified municipality, and residential plot below 200 yards in non-notified municipality area, or until all of these criteria are met. Only if all of these criteria are met, Your Lordship, a person will be.
There are many millions of people in this country who have not even necessarily feel of land.
Indeed, Your Lordship, and the amendment is in fact for those people, Your Lordship, who are not being.
Other OBs and all the criteria of criminal is there. And of course, there is ceiling issue as well. They have otherwise sustained, suffered stigma of social status, etc., or some backwardness in some part of.
Indeed, Your Lordship.
But this community have not suffered. But there is no criminal here. That
Yes.
itself would project as a case of irrational criteria being put forward.
Your Lordship.
Sorry, we have 40% of our
Indeed, Your Lordship.
8 lakh comes to about 63 or 66,000 rupees per month.
Yeah.
And there are thousands of people who work for 10,000 per person. What even
Indeed, Your Lordship. Indeed, Your Lordship. Your Lordship, however.
and this 66,000 person who is getting monthly, we will have a march over those people who are getting only 20,000.
Your Lordship, however, the council would like to reiterate the fact that unless all these criteria are met, only if all these
The
criteria are.
criteria is sufficient first because the person has got said
Yes, sir.
no land at all.
Yes,
The
Your
person
Lordship.
is having 5 acres.
Yes, Your Lordship.
He's also coming under the business.
Indeed, Your Lordship. However, the categories are kept so that there is.
All these categories which you mentioned.
Yes, Your Lordship.
This is basically income.
Yes, Your Lordship.
Income criteria. So
For the-
income is becoming the sole criteria.
Indeed, Your Lordship.
So how will you find out income being the sole criteria? How will you find out the particular person who is entitled for this research?
Your
You
Lordship.
said earlier that it's empowerment.
Indeed, Your Lordship. Indeed, Your Lordship.
Empowerment.
Indeed, Your Lordship. Your Lordship, the council would like to submit before this court that the poorest of the poorer sections have also been experiencing oppression since a very long time, Your Lordship. Even when the constitution was made, even when the constituent assembly debates were being held, this the concept of economic criteria being a criteria for reservations was talked about. It was not taken into consideration. However, years after years, as my learned counsel for the petitioners had mentioned, after 7 decades of independence, Your Lordship, there are still poorer, and the poverty has only increased. In fact, and it has only made poorer more poorer, Your Lordships. And they are not getting any sort of.
So this is an anti-poverty mission.
No, Your Lordship, indeed no. It's an enabling provision so that these people can also come forward and they can also be given an equality of opportunity, Your Lordship. Just like how SC, ST and OBC communities are being given at this point, Your
You're
Lordship.
asking the question there, rationally fixing an upper ceiling limit of 8 lakh.
Yes, Your Lordship.
And those who have a less means in that have been matched over by who have more means.
Your Lordship,
And all the idea of fixing economic criteria becomes irrational.
Your Lordship, however, even for the creamy layer of OBC, that is also kept as at an income ceiling of 8 lakhs, Your Lordship. Below that, anyone who comes under below 8 lakhs is also getting reservation, Your Lordship. In this, the same limit is also kept for the EWS reservation, Your Lordship, that as 8 lakhs. Anyone below, it's the criteria actually, Your Lordship, in the case.
Is fixed as to exclude creamy layer within that social group.
Apologies, Your Lordship.
Because there is a factor.
Yes, sir.
that exclude the creamy layer in the socially backward group by economic factors, saying that they are much forward in their life. Therefore, those creamy layer have to be excluded.
Yes, Your Lordship.
Even though they suffered all social backwardness at some point of time.
Indeed, Your Lordship.
But this community being now benefited by this, no point of time suffered such
Your Lordship, the council begs.
adversity in the life.
Your Lordship, the council begs to differ in this manner that they have also been oppressed just because of the fact that they are poor, Your Lordship, and also because of the fact that they were born into the forward caste, Your Lordship, which is not even their fault. They were born into a forward caste. This a particular forward caste family is poor, and because of this, they are not getting representation, or they are not able to avail education, Your Lordship.
See,
And
how do you analyze in a philosophical way what matters ultimately in social, cultural life? Factors one's dignity or approach to life, etc. why that reservation is brought to the as a concept of the constitution, why it has been brought. It's not because of the poverty or economic factors alone, because there are indeed several factors which influence one's needs, one's role in the society.
Indeed, Your Lordship.
Let me give a simple example like this. The Brazilians and Indians have same history. But we can't play as much as football Brazilian can play. Everybody born in that country can. Even we try best in our ability, we cannot compete. Similarly, the Brazilian can't play the same way the Indian play the cricket. All physical, vitals are same almost. Why?
Your Lordship,
Why that? Indians are trying best for playing football, but not able to achieve that. But if you can find Brazil or the Mondo or Argentina, Messi, why?
Your Lordships, the Council would like to submit before this court
So
that
there are many social factors.
Indeed, Your
influence
Lordship.
one's life.
Indeed, Your Lordship. The Council agrees to this point of view of this court, Your Lordship.
Maybe
However,
the gene itself, maybe there are many factors.
indeed, Your Lordship. Indeed.
Anthropological way of looking at it. There are many factors influence one's growth.
Indeed, Your
The
Lordship.
economic surroundings not necessarily should be.
Indeed, Your Lordship. However, just because of the fact that these people or a particular class or section of people were born into an upper caste family, and these upper caste family, there are section of upper caste family that are poor, Your Lordship, and they are not able to avail education or being represented in the state, Your Lordship. By this reservation, just like how a percentage of reservation is, a percentage of seats are reserved for the SC, ST and OBC communities, can also be reserved for the poorest of the poorer sections of the society, Your Lordship, which is why this EWS reservation was brought into place.
Which means it should apply to all. There can't be any distinction at all. You have to give reservation to all whose income is below middle income.
Your
There
Lord,
cannot be any distinction in that.
indeed, Your Lordship. Your Lordship, however, the Council begs to differ in the manner that SC, ST and OBC communities are already receiving, apologies, Your Lordship, receiving reservation, and it would amount to double benefit. They would again and again get reservation, then the opportunity.
The larger frame of the population, demographic statistics.
Indeed, Your Lordship.
SC and ST constitute
A larger population. Indeed, Your Lordship. Indeed, Your Lordship.
50%.
Your Lordship, that is the
Forward community which may be constituted of a HMIC district, small in number. So they get more benefit now.
Your Lordship,
Coming to SC and ST.
Your Lordship, the reservation that was kept, the 50% cap was kept for appropriate representation, Your Lordship, and not for proportional representation. When the problem, apologies, Your Lordship, the problem of reservation when it had come before this court, it had considered the population, the total population of SC, ST and OBC in the country, and it had decided that we cannot give such a large amount of reservation for even though the population is high, and they've kept the 50% cap so that appropriate representation is being given to these communities. In this similar way, Your Lordship, for a particular percentage of the population that is poor and economically weaker, for them only this 10%, which is a 10% cap, Your Lordship, anything below 10% can be reserved for these poorer sections, Your Lordship.
Anything below also can.
10% is a limit, Your Lordship. It's the cap, Your Lordship. Nothing more than 10 can be permitted.
Yes.
Your Lordship, the Council seeks permission to move on to the prayer. If the court is satisfied with the arguments of issue 1, issue 3 and 4. Much obliged.
You want to dismiss it with the cost?
Your Lordship, the Council will be asking that in the prayer.
Yes.
Much obliged. Wherefore, in the light of the issues raised, arguments advanced, and authorities cited, the Council for the respondent humbly pray and implore before this honourable court to kindly adjudge, hold, and declare that the review petition is not maintainable, the judgment under review was not made in error of law, the Constitutional Amendment Act of 2019 is not violative of basic structure doctrine, fixation of income ceiling is not arbitrary, thereby not violative of Article 14, or pass any writ, order or direction which the court may deem fit in the end of equity, justice, expediency and good conscience in favour of the respondent, and for this act of kindness the respondent as in duty bound shall forever remain obliged. All of which is humbly prayed. Unless the court has any further questions, that concludes my submission on behalf of the respondents. Much obliged, Your Lordship. It was an honor to plead before this court. Much obliged.
The expression error apparent on the face of record is an error which is based on clear ignorance or disregard of the provision of the law. In MS Allahabad versus State of Haryana, it was observed. Lordship, I shall establish why it is important. It's the duty of this court to, if the duty of the court is to actually somehow guard the justice, and if some doubt occurs in the justice, it becomes the duty of the court to solve it, to address it. That is the maintainability. In MS Allahabad and versus State of Haryana, it was said, and I quote, to perpetuate an error is no virtue, but to correct it is a compulsion of the judicial conscience. Same way, in Common Cause Society versus Union of India, much recent judgment of 2018, on the review petition, the court reversed its own earlier judgment on the ground that it is suffered from patent error of law resulting in serious miscarriage of justice. The provision's judgment is favor of 103rd Amendment Act 2019 showcase similar erroneous grounds. It is humbly submitted before this court, Honorable Court, the review petition is filed to prevent gross miscarriage of justice on the earlier decision of the court upholding 103rd Amendment Act 2019, failed to deliver complete justice and resulted in palpable injustice of the public. In Bharat Seva Sanstha versus UP Electronic case, it was held, the Supreme Court in exercise of jurisdiction can grant appropriate relief where there is some manifest illegality or where there is manifest want of jurisdiction, or I highlight, Your Lordship, or where some palpable injustice is shown. It has resulted in the parties. Under Article 142 Clause 1, the Supreme Court is entitled to pass any decree or make any order as it is necessary for doing complete justice in any matter pending before the court. This article contains no limitation regarding the cause or circumstance in which the power can be exercised, nor does it lay any condition to be satisfied before such power is exercised. Your Lordship, addressing what my counsel said, learned counsel said that the present case does not breach Chandra Savari case. Counsel said that back then there was no rule of law for economic reservation. This very compulsion favors the motion of petitioner counsel. The question is still based upon the constitutionality of present amendment, whether there should be such a law or not. Not qualifying Article 46 by excluding SCs, STs, OBCs, not qualifying intelligent or differentia of Article 14 and the extraordinary ground. Since right now, Your Lordship, it was never mentioned what is the extraordinary ground onto which such and such reservation should be given. The reason that Chandra Savari case still makes a ground to intervene in this particular case is solely because the government still has not established the conditions and functioning of EWS. The vagueness invites the alert. And we need to take care of the balance strike in an Indra Swani case. There has been no conscious discrimination against the class of EWS. My learned counsel said it dates back to in history. There has been no conscious discrimination against the class of EWS. They have not experienced historical discrimination. Until 2019, through this amendment, there was no such class previously recognized by the court, and my learned counsel says this exists since a long time ago. The entire contention of the respondent in total is based upon poverty, a global, heinous problem. But how can we imagine dealing with poverty through reservation, which in itself is an exception to Article 14, and it is an exception in the Constitution which is practiced for upliftment. It is not a medium. How can we imagine to use it as a medium to elevate poverty? My learned counsel keep quoting poverty. There is poverty. Poverty is a global issue. But how can globally or even as a country we can think to use reservation for such and such purpose? This is a diplomatic failure. This is the failure of lots of policies have been there. I have submitted the report of the policies that caters very same points that EWS wants to tackle. Other than strengthening those policies that already strengthened, the reservation is being used as a scapegoat, Your Lordship, to skip the entire burden. That entire policy system is a failure in the country right now. The policies that already cater such and such need of everybody with equality principle are not being dealt with properly, and the reservation has been used as a scapegoat, Your Lordships. Can we really, in the conscience of country and with the philosophy of reservation and with the present constitution, official, having a home, earning a particular income, all are economic pursuits, Your Lordship. The council was itself confused. The council somewhere. I humbly submit. Much obliged.
They gave a traffic example. Enough? You want? Yes.
What time? Just get what time?
Obliged, Your Lordship. With permission, the Learned Counsel for Petitioner states that during the Chandra Saveri case was considered when the respondent counsel said that there was no economic reservation allowed. Just because there was no economic reservation when the Chandra Saveri case was considered, that does not make the legislature, they did not do the economic reservation after that 1992. There is no such provision. And moreover, what was stated was that extraordinary circumstances was not dealt with. The extraordinary circumstance is that actually the inevitable truth is that law is not static and immutable, but ever increasing in a dynamic and flows with ongoing passage of time. In the given circumstance, the extraordinary circumstance is that now after backward class based on the caste was given, now the legislature is proposing to give a 10% reservation to the economically weaker sections of the general caste who did not have any opportunity of reservation till then. And that is an extraordinary circumstance. Much obliged, Your Lordship. It was a great pleasure to meet before you.
Judgment reserved. I think